Hi guys, welcome back to Nairobi Legal Insights. In today's video, we're going to be looking at the topic of termination on account of redundancy. And for us to appreciate this topic in a practical sense, we're going to be reviewing a case summary. And this specific case was ruled in the Employment and Labor Relations Court, Mombasa. And we're going to look at the summary of facts of the case, the legal issues that came out, the decision of the court, and the reasoning behind the decision of the court. So please stick around to understand how the court will look at any case to do with redundancy. We are going to be reviewing the case of Kavudha Ngozi and 11 others versus EPZ Limited, and a full citation of this case is provided should you want to read the entire case online on Kenya Law Resources. Moving straight into the facts of this case, Ms. Ngozi and 11 others were employed by EPZ Limited from diverse dates starting 1st September 2001. They were employed on the basis of fixed-term contracts, and these contracts were reviewed consecutively, and in fact, the last contract started on January 2015. On the 3rd of July 2015, they were all terminated on account of redundancy by a letter dated 2nd July 2015, and when this happened, they sued EPZ Limited alleging that their employment was unfairly terminated without EPZ following Section 40 of the Employment Act of Kenya. Remember that this is the act that sets out the grounds to be followed when terminating an employee on account of redundancy. In this particular case, Ms. Ngozi and 11 others claimed an aggregate sum of over 3 million, and this amount was made up of severance pay, gratuity pay, salary for the unexpired term of the contract, and compensation for unfair termination of their contracts. On the side of EPZ, the company admitted that Ms. Ngozi and 11 others were its former employees and that their services were terminated on account of redundancy. However, EPZ denied that the termination was unfair and averred that the company had fully complied with Section 40 before declaring the positions of these employees redundant. Over and above this, EPZ further averred that it had actually paid Ms. Ngozi and 11 others all their rightful dues as provided under Section 40 of the Employment Act. Now, moving into the legal issues that came up in this case, the first issue was whether redundancy was a valid and fair reason for terminating Ms. Ngozi and 11 others' service as provided under Section 40 of the Employment Act of Kenya. This was the first legal issue. Number two, whether the procedure followed to dismiss Ms. Ngozi and 11 others complied with Section 35 of the Employment Act of Kenya, and whether Ms. Ngozi and 11 others were entitled to the reliefs they were seeking before court. Now, having understood the background of the facts of this case, we've spotted the legal issues. Now we are moving to the decision of the court. In this particular case, the court held that redundancy was a valid and fair reason for terminating Ms. Ngozi and 11 others' employment contracts. It went ahead to state that the procedure followed in laying off Ms. Ngozi and 11 others on the 3rd of July 2015 was fair in compliance with Section 40 of the Employment Act of Kenya, and that the claims for gratuity and arrears of severance pay were also dismissed. This was the decision of the court, and in the course of this video, I want us to understand why the court decided this way. This will give you some insights on what amounts to redundancy and how you can terminate an employee based on redundancy in a valid and fair way. This is the most critical part of this video because we are trying to understand why the court ruled the way it ruled. Why did the court have to say that EPZ had terminated its employees in a fair manner on account of redundancy? So let's understand the reasoning behind the court's decision. Now, EPZ's business was fully dependent on orders from abroad, and one of EPZ's major clients, Shah Safaris, gave notice on the 2nd of May 2015 that she was reducing its orders from this number of pieces to this number of pieces. Now, such reductions in order reduce the amount of labor required to make the new number of pieces that were being ordered by this major client. And the reduced order also meant that the revenue to EPZ was reduced, and therefore it was not economical to actually continue employing all EPZ staff. In this particular instance, it was proper for EPZ to lay off some of her workforce. And also we need to appreciate that the decision EPZ took was permitted under Section 45(2) of the Employment Act of Kenya, which provides that the reason for terminating the services of an employee is fair if it relates to the operational requirements of an employer. Now, to break this down, in this case, the employer did not actually need to retain labor, which had become excessive after her major client reduced the number of, or rather, after the major client had reduced the amount of business. Remember, we discussed that the pieces had reduced from this much to this. So clearly speaking, the court looked at this, and in view of the letter that was dated 2nd May 2015 from EPZ's limited major client on reducing the amount of business to be transacted with her, the court held that redundancy in this particular case was a valid and fair reason for terminating Ngozi's employment contract. So this is the first key point that formed the reasoning of the court. The next key point that informed the decision of the court was that EPZ Limited served notice of more than 30 days on Ms. Ngozi's union and the county labor office. Second, EPZ and the union officials agreed to select employees to be laid off, including but not limited to productivity, absenteeism, low performance, and sickness. So there was an agreement. Third, EPZ Limited also held a meeting with Ms. Ngozi and other workers and notified them of the shortage of work. Remember, the major client had reduced the amount of order. Finally, Ms. Ngozi and 11 others were paid their dues, including salary in lieu of notice, unpaid salary and overtime, accrued leave, severance pay, and arrears of wage increment. All this was already paid to them. Regarding the third legal issue, where Ms. Ngozi and 11 others were actually claiming for gratuity pay for the years served, the reasoning that informed the decision of the court by not allowing this to go through was that the termination of these employees was through redundancy, whose remedy is payment of severance pay under Section 40 of the Employment Act of Kenya. And remember that Ms. Ngozi and 11 others were already paid this severance pay. So, based on this, the circumstances for redundancy cannot actually converge with the circumstances for termination through death or retirement. Now, you can only get gratuity pay if your circumstances fall under termination through death or retirement. And so, it is important to note that Ms. Ngozi and 11 others were not entitled to claim for gratuity pay for the years that they had served, because their termination was through Section 40 of the Employment Act of Kenya, and this was on account of redundancy. Thank you so much for watching this case summary, and I hope you've understood a few things on redundancy. If you are a new person watching content on Nairobi Legal Insights for the first time, please consider subscribing so that you receive notifications every single time we post a new video. And also, if you want to review the entire case, please go to Kenyan Law Resources, and I provided the citation at the beginning of this case summary. Thank you.